Wicked Vision Limited against Ian Rice. Barton Development Limited against Treadwell.
Yes, Ms. Matraghi.
Thank you. My lords, my ladies, the matters before you concern two appeals today. I appear on behalf of the appellants Wicked Vision, together with Mr Cohansard and Ms Vandenberg for Wicked Vision, and my learned friends Mr Solomon KC, Mr Milsom and Ms Sandiford appear for the respondent Mr Rice. Mr Leaper KC and Mr Bidnell Edwards appear for the appellant. In the joint appeal, Barton Turns, and Mr Jubb KC and Mr Canning appear for the respondent Ms Treadwell. In addition, Protect, the whistleblowing charity, appear as an intervener, represented by Ms Jolly KC with Ms Masters and Ms Brown. All counsel are here on a pro bono basis.
Yes, the court is aware of that, and I should say we're very appreciative, and indeed the public generally should be appreciative of the fact that counsel are prepared to represent people on a pro bono basis in the public interest.
Thank you, my lord.
So we're very appreciative.
Thank you. Turning to the substance of the appeal, both appeals concern the scope of the claims an employee who is a whistleblower, i.e. somebody who has made a protected disclosure, may bring under the Employment Rights Act. And the Employment Rights Act is the main source of protection of statutory rights for employees. Under Part 10 of that Act, employees can bring claims about their dismissal, including dismissal caused by whistleblowing. Under Part 5, employees have protection from being subjected to detriment on various prohibited grounds. 14 are identified in the Act now, and that includes detriments arising from whistleblowing. The question in this appeal is whether employees can bring a claim that their dismissal was caused by whistleblowing in Part 5, the detriment section, as well as in Part 10, the unfair dismissal section. The appellants say that they cannot because of an express ouster provision, which is set out in Section 47B2, and is replicated across all other grounds of detriment in Part 5. We say that the only course of action for an individual wishing to complain of their dismissal as an employee is to bring a claim under Part 10. The respondent's position is that they can bring a claim under Part 5 because the ouster bites. This is a matter of statutory interpretation. It is a matter of pure law. And the appeal is of particular significance because the causation tests for Part 5, the detriment part, and Part 10, the unfair dismissal part, substantially vary. Part 10 claims, which are unfair dismissal, have a causation test with a higher threshold to succeed. The tribunal needs to conclude that the claimant's protected disclosure was the reason or the principal reason for the dismissal. Whereas under Part 5, the tribunal need only be satisfied that the detriment to which the claimant was subject was done on the ground that the claimant had made a protected disclosure. That is, that the protected disclosure materially influenced the treatment, which is a lower test, as first recognised in the case of Fessett by Lord Justice Elias, which appears at page 683 of your bundle, the main bundle at paragraph 45, and subsequently endorsed in a number of appellate authorities, including one before my Lady Simler in Osipov at page 1468, paragraph 82. The upshot is that it is advantageous and attractive for a claimant to seek to bring a claim under Part 5 to sidestep the higher hurdle that belongs to an unfair dismissal claim in Part 10, but we say it is wrong to take that course. So the key question, therefore, is whether the ouster in Section 47B2 means what it says, with the effect that claims regarding dismissals can only be brought under Part 10, or whether they may bring two claims in respect of their dismissal, two bites of the cherry, under Parts 5 and 10. And also, specifically in this case, whether the changes made to the whistleblowing detriment provisions in 2013, following the case of Fessett, to which I'll refer, which permitted detriment claims to be brought against co-workers for the first time, for which the employer would be vicariously liable, changed how the ouster operated. We say it made no change to how the ouster operated. I will address you on the core statutory interpretation issue, which is Wicked Vision's grounds 1 and 2 and Barton Turn's ground 1. and that is set out at pages 16 to 17 at paragraph 4D of the appellant's case. The core submission is that there is only one route to claim in respect of dismissal in the case of employees or termination of contract in respect of a worker. We say that is true for dismissal claims whether they are brought on a whistleblowing basis or any other prohibited ground in Part 5 and Part 10 of the Employment Rights Act. For example, health and safety dismissals, dismissals connected to flexible working time cases, and so on.
Although in relation to all of those other protected grounds, there aren't provisions that protect against detriments by co-workers.
That's quite right. The respondents say that it is unique that one may sue a co-worker under the whistleblowing provisions, but we say that that's not material for the reasons I'll go on to address.
But you accept it's unique?
We do accept that it's unique. Unique but ineffective when it comes to looking at the ouster. The architecture and the legislative history since the inception of the Employment Rights Act in 1996 shows that Parliament has kept sacrosanct the distinction between Part 5 and Part 10. It has always kept either a door open to Part 5 or a door open to Part 10, depending on which individual, which type of working person is bringing the claim. And we are also able to show that in certain situations, a Section 197 fixed-term employee that I'll come on to, Parliament closed the door in respect of one part and opened the door in respect of another. And we say that that is very important. My learned friend, Mr. Leaper KC, will address you on the further statutory interpretation issue in relation to remedies provisions applicable to whistleblowing detriment and dismissal, which further supports our reading, and he will go on to address the precedent point relating to Osipov in our grounds 3. He will also address matters arising out of Protect submissions. We have provided the Court with a proposed agreed timetable for all our submissions and the reply of all those appearing, and intend to follow that unless the Court indicates otherwise. So I will be addressing you until approximately 11:40 and Mr. Leaper until 12:30. May I check at this juncture if you have received through the portal or otherwise the supplemental bundle that was submitted this week on Monday?
We got a supplementary bundle a few days ago, I think, and I at least received about 10 minutes ago 2 further documents.
Thank you very much, my Lord. That is simply to make sure that you have the relevant provisions at the relevant time and a further case referred to by Protect. To set out the structure of my submissions, I intend to make some preliminary remarks to set the scene, then secondly to address you in brief terms on the principles of statutory interpretation, thirdly to set out our points regarding the statutory framework and the importance of understanding the legislative history, and then finally to make submissions on the primary ground of appeal by reference to those principles of statutory interpretation. So, to the preliminary remarks, as this is a pure legal issue, the facts are not material. Both cases are at the very start of the adjudicative process and no evidence has been heard. In both appeals, the claimants brought whistleblowing claims, claiming that they had been unfairly dismissed because of their protected disclosures, and subsequently both sought to include, by way of amendment, claims that they were subjected to an unlawful detriment, namely that same dismissal, relying on the vicarious liability of their co-workers. No claims have been brought against the individual co-workers. In Wicked Vision, the Employment Tribunal permitted the amendment, and in Barton terms, in respect of the same issue, the tribunal did not. In the EAT, the position was reversed, where the Wicked Vision EAT overturned the granting of the amendment, and Barton terms overturned the failure to grant the amendment. In the Court of Appeal, Lady Justice Lang, with whom Lord Justice Peter Jackson and Lord Justice Coulson agreed that it was bound by an earlier Court of Appeal decision, Osipov, which Mr. Leaper will address further in due course, but concluded that had they been free to depart from that decision, then, which they were not, that they would have done so, as they respectfully disagreed with the interpretation of the legislation. However, there is and has always been, for this section on protection from detriment, a disapplication provision at 47B2, which excludes detriment claims insofar as they relate to dismissal. And that states in terms, and if I can refer to that at page 194 of the main bundle, it states, this section does not apply where the worker is an employee and B, the detriment in question amounts to dismissal within the meaning of Part 10. We say in summary that these, in the Court of Appeal was entirely right to reach the conclusion that they did on the correct construction of 47B2, that on a plain and natural meaning of the statutory words, it does what it says on the tin. It disapplies the whole of the section to any claim amounting to dismissal, which is clear and unambiguous, and that it's consistent with the two separate, parallel, mutually exclusive, one might even say hermetically sealed regimes, which apply to employees, and I underline the word employees on the one hand, and workers as it applies on the other hand, such that only employees go through the door of Part 10 and the door of Part 5 is closed, and only workers go through the door of Part 5 and the door to Part 10 is closed. Although the scope of who is covered by protection from detriment on certain prohibited grounds has expanded in recent years to cover workers, who are a wider category than employees, what has never changed as a matter of statute is that there is only one door that an employee or a worker can go through. Now, workers, by whom I mean individuals who are workers but not employees, also have that one route, as I have said, and the disapplication provision in 47B2 does not apply to them because they are not employees and they have no protection within the meaning of Part 10. So turning now to Part 2 of my submissions on statutory interpretation.
Just before you do, can you just help me to understand the practical importance of all this?
Yes.
Not all of us are as familiar as Lady Simler with employment disputes.
Yes.
I can see that there may be cases, this isn't one of them, but there may be cases where in practice there's no real remedy available against an employer, for example, because the employer is insolvent.
Yes.
And the employee might therefore want to seek a remedy against fellow employees who had victimized him or her. Right? But that's not these cases.
Yes.
So in these cases, is the only practical advantage in proceeding under Part 5 of the Act the lower test of causation?
That's the sort of superstar benefit that you get by significantly lowering the causation threshold. Mm-hmm. But there are also other benefits, one of which is that detriment claims attract injury to feelings awards. And on one authority, Virgo Fidelis, that would indicate that one gets injury to feelings in respect of a dismissal under Part 5, whereas in Part 10, unfair dismissal, no such remedy exists. Yeah. There are some advantages the other way in relation to Part 10. Under Part 10, one gets a basic award, which is an amount which is linked to the length of time that an employee has worked for an employer, which is not available under a detriment claim under Part 5. And it is only under Part 10 that one could potentially get an order for reinstatement, re-engagement, or to seek interim relief, which is so that the contract continues even after a dismissal. So there are differences which make one or other more advantageous, but clearly a lower causation threshold is particularly advantageous for an employee who's seeking to win on whatever basis.
Yes, and the injury to feelings awards are obviously important because you're actually going to recover, if you're successful, higher damages under...
Yes.
Or higher award under Part 5.
Indeed. That would typically be a 5-figure sum in a Vento band there's 3 levels of injury to feelings award, so that could be a very significant sum on its own, of particular value to somebody who is a lower paid worker, for example.
Is the different level of different threshold for causation, is that a distinction that exists for all the Part 5 protections?
It is.
As compared with the Part 10 dismissal?
It is, my lady. It is it is the same. So,
and is that something that's clear from the statutory wording in each case, or is that a judicial interpretation that's been?
The same wording applies on the ground that in 47B, which is the whistleblowing detriment, and in others such as 44, which is health and safety, 45A on working time, etc. And I don't have at my fingertips whether there has been specific judicial interpretation of those other provisions to say on the ground that, but one would read across using the canon of construction that those phrases and terms should be interpreted consistently across the same part and across the same act. So I'm not familiar with any suggestion that they should be read in any different way.
But the statutory wording for the detriment provisions is always on the ground that.
It is.
Whereas for a dismissal, whether it's ordinary unfair or a protected automatic dismissal, is always the reason or principal reason.
It is indeed. And I think it's worth mentioning that unfair dismissal protection came well before protection from being subjected to unlawful detriment on prohibited grounds. So what we start with is the bedrock. I mean, literally, redundancy payments came first, but next came unfair dismissal rights. So the paradigm has always been the reason or principal reason test that's set out in the unfair dismissal provisions. The later entrant is the on the ground that test that's in Part 5 that relies on, that attaches to detriment claims.
But it must have been, or do you accept it must have it's a deliberate decision of the drafter not to import the principal reason wording from Part 10 into the detriment provisions?
Indeed it was, and in fact that was a matter that was under discussion in the Court of Appeals case in Fessett before Lord Justice Elias and others, and indeed at that time the employer was arguing that on the ground that did mean reason or principal reason, and was unsuccessful in making that point.
And it may be thought that the on the ground that test was borrowed from the discrimination provisions.
It may be, yes.
I know there's no read across, but those are the words.
Those are the words. But, my lady, as you rightly say, real caution needs to be applied in importing Equality Act concepts into the Employment Rights Act because of the differing context, which I'm happy to address you on should that be helpful.
Is there any cap on Part 5?
There is no cap on Part 5.
And there is a cap on Part 10?
There is a cap on Part 10 only in respect of ordinary unfair dismissal.
Right.
The claims that we're addressing here are automatically unfair claims where you don't assess the fairness, and there is no cap in respect of those.
Right.
So,
sorry, just one final question from me anyway for the moment. With this difference between Virgo Fidelis and the Dunici case, is the basic award in Part 10, what is that directed at, or why is that basic award? What is that supposed to be compensating the unfairly dismissed?
That's a good question. It is equivalent to the amount that one would receive as a redundancy payment. It is based on the years of service times by the number of times by a multiplier of 1 if you're under the age of 41 and 1.5 if over the age of 41. And I think it's effectively loss of a job, some sort of way of recognising that. But it isn't supposed to be directly compensatory. There is a compensatory award that is made in respect of unfair dismissal claims, which is linked to the actual loss incurred by the claimant by not having that job, being out of pocket while looking for another job.
But it's not treated as... There was no argument, well, you don't get injury to feelings for unfair dismissal because that's effectively covered by the basic award.
No. No. And I think it's also worth saying here that the claimants, they want to have their cake and eat it. They don't say, oh, well, we're just going down the Part 5 route, or even in an individual case, we'd only go down the Part 5 route and ignore Part 10. What they're saying is, no, we can have both at the same time. We can have a Part 10 claim for dismissal and we can have a Part 5 claim for dismissal.
How does a tribunal then make an award at the end of it? Say, for instance, the claim against the employer is successful under both Part 5 and Part 10, and different amounts of damages are assessed under each part.
Yes.
What do you do then?
Well, with the greatest of respect, I might suggest that that's for them to answer rather than me. So yes. Of course, there are plenty of cases where there is a dismissal claim under Part 10, and the employee is also saying, well, hang on a second, I was subjected to other detriments. For example, I wasn't allowed to work overtime, or I wasn't allowed to take my, attend a meeting or something, and they may get injury to feelings in respect of those amounts, and will get the basic award as well as any compensatory award in respect of the Part 10 claim.
You may also have a dismissal that is both unfair and discriminatory.
Yes.
And the tribunal will not give you the same award for each. It will reflect the fact that there is inevitably overlap. Yes. And avoid double recovery.
Yes, certainly. I don't think anybody's suggesting that there would be double recovery, but there are unique parts to claims that, as my lady has already identified, in relation to Part 10 claims and in relation to Part 5, and my understanding is the respondent wants both of those, or all of those, as the case may be.
So I'm sorry for interrupting again. If the detriment is dismissal and that's successful under Part 5, and the claim for dismissal under Part 10 is also successful, double overlap would then involve what in calculating damages? Compensation.
In calculating damages, well, under Part 10, one would get the basic award. One would get a compensatory award which reflects how long they have been out of the job market or the lower paid job, etc. Under Part 5, one would similarly, if one was permitted to do this, and of course that's complete heresy on our account, that's not permitted, but there I suppose you would say, well, the compensatory amount that they're seeking, you would cross it out because they've already got it under Part 10, but you would also get a injury to feelings award under Part 5. Thank you. So with those introductory remarks, I'll move on to statutory interpretation. Of course, the general approach to statutory interpretation is well established and most recently reiterated in this court in For Women Scotland. So no introduction really needs to be given to that, given I stand before the authors of that judgment. So the courts, in conducting statutory interpretation, are seeking the meanings of the words that Parliament used. And if I might just assist with your own judgment by at least providing the pages that that refers to in the bundle, pages 757 to 758, so you have those at your fingertips. Secondly, words and passages in a statute derive their meaning from the context. A phrase or passage must be read in the context of the section as a whole and in the wider context of the relevant group of sections. And we say nowhere is that more important than in this case because of the statutory scheme and the history. Thirdly, that the words used are the words that Parliament has chosen to enact as an expression of the purpose of the legislation and are therefore the primary source by which meaning is ascertained. And fourthly, to stress the important constitutional reason for having regard to the statutory context as set out by Lord Nichols in the case of Spath Home, that citizens, with the assistance of their advisers, are intended to be able to understand parliamentary enactments so that they can regulate their conduct accordingly. And we say that's also particularly important in this context because in employment tribunal litigation, one is frequently appearing before the employment tribunal as a layperson, or perhaps with the assistance of a layperson, or maybe having obtained advice from Citizens Advice, Protect, others. And so these provisions need to be instantly accessible, understandable, and clear, and we say they are. And by contrast, we say the interpretation given by the respondents is tortured and inconsistent. So let's look then at the legal framework of the Employment Rights Act, some of which we have already considered. Standing back, although the Employment Rights Act is the main source of statutory rights for individual employees, as I say, some of those terms go back to 1965 with the Redundancy Payments Act, as recorded in the judgment of the Court of Appeal at page 112 of your bundle, paragraph 27. Subsequently, unfair dismissal provisions enacted under the 1971 Act. And more recently, a mere 30 years ago, in 1996, a 15-part statute, which includes Part 10 and Part 5. Now, I should just say as a footnote, and this is not one of the many sections we've introduced into the supplemental bundle, even before 1996, the Employment Protection Consolidation Act had within it Section 22, which drew this same distinction between detriment and dismissal. And what it did is it set out that there was effectively dismissal and action short of dismissal. And that was in the context of health and safety advisors carrying out their health and safety activities or raising safety concerns. So that's Section 22A of the Employment Protection Consolidation Act, which was introduced in 1993. And similarly, there was a similar distinction for trade union activities for dismissal and action short of dismissal. That is set out in some detail in the appellant's case, the history of the Act, which is at pages 21 to 29, and in view of the short time available, I don't go into that any further.
Have you got section 22 of the EPCA in the bundle?
We don't, unfortunately, but we're very happy to provide that today.
And is the trade union action short of dismissal the same provision, or is it a different one?
That is section 23 of the EPCA.
We have both?
Yes, certainly, my lady. So, in the short time available, I want to emphasise 5 points of particular importance to the architecture and the legislative archaeology, if I could put it in those terms, to assist in how Section 47B2 should be construed. Firstly, and possibly most importantly, what does amounts to dismissal within the meaning of Part 10 mean? Both in Section 47B2 and its equivalent disapplication provisions in Part 5. Secondly, who gets protection under Part 5? Thirdly, how has the ouster changed over time? Fourthly, what is the effect of the 2013 changes?
You're going a little too fast.
Apologies.
Sorry.
What was third?
Third is how has the ouster changed over time? Fourthly is what is the effect of the 2013 changes, which brought in co-worker liability? And fifthly, remedy. So dealing first with what does dismissal within the meaning of Part 10 mean, that is the central component in this case. And the appellate courts in Timis and Osipov and in the combined appeals in this case have treated them in diametrically opposed ways. We say that the Court of Appeal's decision in this case is to be preferred because that is the one that reflects the architecture and the legislative history. So the first part to note, I believe it's at page 1866. I might invite the court to turn that up. Is section 95 is the dismissal section within Part 10. So this explains within Part 10, the unfair dismissal part, what is a dismissal. It's headed circumstances in which an employee is dismissed. And you will see at the very start of that provision, it says, for the purposes of this part, an employee is dismissed by his employer and subject to subsection 2 only if, and it sets out 3 situations. So I'd ask you to underline for the purposes of this part. So when we read back to 47B2, it says we're looking at dismissal within the meaning of Part 10, and here we are. This is section 95. This is what dismissal means for the purposes of Part 10. And so it is A, whether the contract under which he is employed is terminated by the employer, whether with or without notice. That is, if if one might describe the classic form of dismissal, employer ends the contract. Secondly, he is employed under a limited term contract and the contract terminates by virtue of the limiting event without being renewed under the same contract. For example, you're employed for a year until the 31st of March, and at the end of that year, 31st of March, my contract is not renewed. That counts as a dismissal. Thirdly, the employee terminates the contract under which he is employed with or without notice in circumstances in which he's entitled to terminate it without notice by reason of the employer's conduct, i.e. a constructive dismissal. So the respondent's case on this is that the reference to in the ouster to dismissals within the meaning of Part 10 means that it is excluding dismissals which are unfair dismissals from the ouster. We say that that interpretation is wrong, notwithstanding the judgment in Osipov, misunderstands the legislative history, and the true position is that dismissal within the meaning of Part 10 is simply flagging the relevant definition of dismissal. It is flagging the act. It is not flagging unfair dismissal, which is a cause of action. And that becomes clear when looking at the legislative history. So we've looked at the central definition here in section 95, but what there is no reference to within the Osipov decision or in the EAT's decision in Osipov is the alternative meanings of dismissal that are present within the Act. So Part 10 has this definition of dismissal and one other which no longer applies, which I'll come back to. Part 11 has a slightly different definition of dismissal. So under Part 11, this is dismissal for the purposes of calculating whether somebody is entitled to a redundancy payment. And I'd like to take you to section 136.
This is the different definition of dismissal in Part 11.
It is, yes, my lady. Thank you. And I just paused.
Which page are we on, the bundle?
Yes, I'm just seeking to find that, my lord. I have seemed to... It's the supplemental bundle. Thank you. Thank you very much. That's in the supplemental bundle. Page 13. Thank you very much.
Page
15, thank you very much. That's the current version of the definition, and 13 is the original version of the definition. So you can see subsection 1, for the purposes of this part, an employee is dismissed by his employer if and only if. And you see at A, the contract under which he's employed is terminated by the employer, so replicating the employer's express dismissal in section 95. B, he's employed under a limited term contract and that terminates by virtue of a limiting event, also replicating what we see in 95. And C, employee terminates the contract under which he's employed in circumstances where he's entitled to terminate. So that is the constructive dismissal part. However, you will see under paragraph 2, subsection 2, subsection 1C does not apply if the employer terminates the contract without notice in circumstances in which he's entitled to do so by reason of a lockout by the employer. So this is a slightly different situation. It has a slightly narrower scope for constructive dismissal than in Part 10. And you will also see that at the start of this section, it says subject to the provisions of this section and sections 137 and 138. Those are the two loose-leaf sections that we provided this morning. And there are two of those, the first of which at 137 is a now repealed section, which says failure to permit return after childbirth is treated as dismissal. And in that case, it says subject to subsection 2 and 138, where an employee who has the right conferred by section 79, that's the right to take ordinary maternity leave, and has exercised it in accordance with 82, that is following the process that was then required, and is not permitted to return to work, she shall be taken for the purposes of this part to be dismissed for the reason for which she was not permitted to return, with effect from the notified day of return. And then at section 138, this is a point of distinction with section 95 and part 10. There is no dismissal in cases of renewal of contract or re-engagement. So that is a further differentiation as compared with part 5. And I would also make this point. I pause to observe that in the same way that section 136 defines dismissal within part 11, the part on redundancy payments, this dismissal provision does not tell you whether you're entitled to a redundancy payment. It just defines what dismissal is. And that's the same job that section 95 is doing in part 10. There is one other important piece of legislative history which deals with why the signpost was to part 10 and not, as the appellants say, it should have been to section 95. And that is section 96, which appears in your supplemental bundle at page 10. That is headed failure to permit return after childbirth. Similar provision to that just seen in respect of part 11. And what that provided for between 1996 and 1999 was effectively, we see an employee who has the right conferred by section 79, that's the right to take ordinary maternity leave, has exercised it in accordance with section 82, is not permitted to return to work. She shall, for the purposes of the provision, subject to the following provisions of the section, be taken for the purposes of this part to be dismissed. So
was this still in part 11?
This is now in part 10.
Part 10.
This is in part 10.
Yeah.
So, in short, where the employee has a right to take ordinary maternity leave and exercised it using the procedure designated in by statute at the time, but isn't permitted to return to work, they are treated as dismissed. Of course, there are some disapplications which are covered further in the section, which need not trouble us. But absent that provision, the contract of employment for the woman who had taken maternity leave would not automatically continue and would not also be counted as a dismissal. Now, this provision was repealed with effect from the 15th of December 1999, some 3 years post the introduction of the Act, and significantly also post the introduction of the whistleblowing provisions, which were introduced in July of 1999. And for your reference, page 319 of the bundle is the first version of section 47B. The reason for the repeal isn't because that was thought not that something that should be marked as a dismissal, but because there was the introduction of the maternity regulations. So accordingly, where the drafter has referred to dismissal within the meaning of Part 10, this encompassed both the dismissals designated within Section 95 and also the deemed dismissal in Section 96, both of which were in force at the inception of the Act and indeed at the introduction of the part of whistleblowing 47B. So again, Part 10 is to assist in identifying the act of dismissal that's within scope for the 47B ouster, and it is not a reference to a claim. It's not a reference to unfair dismissal. So accordingly, it is effectively a large signpost, a hand pointing to the act of dismissal that needs to be taken into account. That's my first point. So I move now to who gets protection under Part 5.
Just to, maybe you're coming to this, but do you accept the Court of Appeal's decision in Malia that what you're talking about when you're looking at constructive dismissal for the purposes of applying 47B, that the dismissal is the moment of resignation rather than the pre-resignation behaviour on the part of the victimising co-workers?
Yes. Well, if we go back to 18 66, I think it is, in the bundle,
Yes.
to see the definition. It's the employee terminates the contract under which he's employed with or without notice. So if the employee ends the contract with notice, that's a possibility. You can claim constructive
No,
dismissal.
I'm not talking about whether it's the nasty behaviour by the co-employees is the conduct. I mean, it seems to be in C attributed to the employer there, but as I understand it in Malia, they said that the cut-off point between detriments short of dismissal and dismissal is not looking at when was the point that it got so intolerable that I had to resign. It's looking at when did I resign.
The point of resignation, yes. And I believe Mr. Leeper will deal with that in due course.
Right.
Thank you. So turning to who gets protection under Part 5 of the Act, that has changed over time, and that has implications for the application of the interpretation of the ouster. The Act originally provided protection against detriment only for employees. That was in the 4 original sections: health and safety, Sunday working for shop and betting workers, and incidentally, one should not be misled by the reference to worker. Shop and betting worker is in fact an employee. Section 46 on trustees of occupational pension schemes and Section 47 on employee representatives. All gave protection only to employees.
And only by employers.
And only
By employers.
Only by employers, as against employers, that the claim could be made.
Yes,
Yes, my lady, that's right. The detriment provision was formulated in the same way.
But the word employer always covers you. Even if you're a worker and not an employee, then the person that you work for is called the employer.
Yes.
Yes.
Yes,
It's
that's
a broader term than employee.
Yes. We can come to the definition section in section 230 in a moment. If helpful, we can go there now.
No, that's fine. Yes.
Thank you.
Could I just be clear, in answer to my lady's question, that you're saying that the way you apply 47B2 to constructive dismissal cases is that the detriment has to be regarded as the employee's termination of the contract rather than the circumstances for which the employer is responsible, which entitle the employee to terminate.
That's right. Yes.
Right. Okay.
Yes. So looking at the detriment provision, we're looking at 47, the original beneficiaries of these sections, employees only. As a result of it only applying to employees, one didn't need to specify in the ouster that it applied to employees in circumstances where the detriment amounted to dismissal, because only employees received the protection in the first place. So now, in the late 90s, a number of new rights were introduced for workers, not just employees, this wider category. And at supplemental bundle page 20, we see the first version in the Employment Rights Act from 1996.
Was there something for fixed-term workers right from the beginning? So the ouster was there?
The ouster was there, yes, that's right. And I will come on to that in just a moment. I'm happy to take it now. That is in relation to the special situation of Section 197 employees. So that is dealt with in a now repealed provision. If I can take you to the page 342 of the bundle, you'll see it says superseded at the top. It was in force for 3 years. And this set out that Part 10 didn't apply to dismissal from employment under a contract for a fixed term of 1 year or more if the dismissal consisted only of the expiry of that term without being renewed, so it's a non-renewal case, and before the term expired, the employee had agreed in writing to exclude any claim in respect of rights under that part. So in other words, if you're an employee and you're on a fixed term contract for 1 year or more, and you have agreed before your fixed term contract expired that you would exclude any claim under Part 10, then you could not bring a Part 10 claim. And so uniquely, for these employees only, as the door to Part 10 was closed, the door to Part 5 was opened. And we'll see that in the original section of 47B. Can I take you, please, to page 319?
But isn't redundancy dealt with under Part 11?
Yes, Madam, sorry, my lady, this, if I can take you to page 342 again, this deals with Part 10 claims in section 1971. So this is about employees, as employees normally have the right to bring a claim for unfair dismissal. This is uniquely shutting the door to employees who might otherwise get the right to bring a claim for unfair dismissal. And what Parliament does at this point is, having closed the door on unfair dismissal, it opens the door to being able to bring detriment claims for whistleblowing.
So if you agree to exclude your right to a redundancy payment, in effect you're also agreeing to exclude your right to an unfair dismissal payment.
Forgive me, I'm not sure where... you're looking at Part 3, I think, subsection 3. I'm inviting the court to look at subsection 1, which is in relation to unfair dismissal. This is at the top of page 342.
Oh, I beg your pardon, yes.
So, just to be clear, when Section 47B was first introduced,
yes,
was the ouster only doing the work that related to Section 197?
The ouster was effectively in the same terms that it is now, with a special carve-out for Section 197, and I'll take you
That's
to that
what
now.
it was for?
That's what it was for, indeed. So if we look, please, at page, I think it's 319. So this is the very first incarnation of Section 47B. If we look at paragraph 2, it says, this is the ouster provision, except where the worker is an employee who is dismissed in circumstances in which, by virtue of Section 197, Part 10 does not apply to the dismissal. A bit of a mouthful, but that's the carve-out here. That's what we were just looking at in Section 197. It says this does not apply where the worker is an employee and the detriment in question amounts to dismissal. So in other words, if you're an employee, you're outside, you cannot bring a claim of the detriment of dismissal. But if you are a Section 197 employee, that doesn't apply to you. So you can bring a claim for the detriment of dismissal. Now, when we look ahead to the what happened when Section 197 was repealed, we see that wording was removed. And if you just bear with me one moment, I will find that section. So yes, we will see page 321. This is now post-repeal of Section 197, after October of 1999. This section does not apply. You see the brackets around this. That's because the carve-out for the special 197 employee has been removed. And the reason why Section 197 was repealed is because other provision was made for those employees. They were permitted to go through the door of Part 10. They could bring unfair dismissal claims.
So what work was the ouster doing now at that point?
At this point, the work that the ouster is doing is closing the door to any employee, whether fixed term or otherwise, to bringing any claim for detriment amounting to dismissal under Part 5.
But yes, and they would have been identical claims because they could only be made against the employer.
Yes. So if I go back to where I was in terms of who gets the benefit of this protection, as I said, in the 1990s, a wider category of working people were protected under some of the provisions. And if I can take you, please, to Supplemental Bundle 20, page 20, we can see the scope of Section 230 on employees and workers. So we see at 231, employee means an individual.
I'm so sorry, which page?
It's Supplemental Bundle, page 20, my lady.
Thank you.
And it says, in this Act, employee means an individual who's entered into or works under, or where the employment has ceased, worked under a contract of employment. So that's the central tenet of being an employee. You're working under a contract of employment. And then under paragraph 3, a worker is, for the purposes of this Act, a worker is an individual who has entered into a contract of employment. So it's a worker is an expansive term that includes employees and these others. And the others are those identified in 3B, works under any other contract, whether express or implied, and if it's expressed, whether oral or in writing, whereby the individual undertakes to do or perform personally any work or services for another party to the contract, whose status is not by virtue of the contract that of a client or customer of any professional business undertaking carried out by the individual. Now, this is the version that originally applied. In later versions, once the protected disclosure provisions came into force, that was modified so that it included a yet broader definition of an extended definition of worker under Section 43K. And if I can invite you to look at page 211 of the main bundle, you can see who that includes. So this is, it sets out, and this is not the very original version of Section 43K, but it's clear from the lettering, which is an original section and which is a later addition, and for the point I seek to make, it doesn't make a difference. But you can see that there are a wider category of individuals who are included, that include, for example, some individuals who are on certain training courses. It includes some forms of agency worker and others. So the two prohibited grounds that were introduced after the 1996 inception of the Employment Rights Act were working time, protection against detriment relating to working time cases, which you see at page 229 of your main bundle from October of 1998, and protected disclosures at page 319. Importantly, as I've said, the ouster only changed in one respect, apart from the Section 197 removal of the carve-out, and that was to introduce that the ouster applied where the individual was an employee. So it didn't seek to remove workers from the ouster. It only sought to remove employees from that ouster. And finally, there has been one prohibited ground which has changed over time, originally applying only to employees and over time now applying to workers in certain respects, and that is the health and safety cases provision. For those health and safety cases, following a judicial review in which the IWGB trade union was successful in showing that the EU directives had been inappropriately transposed into domestic law, that was widened so that in respect of certain health and safety cases, the protection applied to workers as well as to employees.
Forgive me if I've missed something, but workers wouldn't have any remedy under Part 10, would they?
Workers would not have remedy under Part 10, that's right.
In which case you wouldn't expect the ouster in Section 47B to apply to workers.
Indeed. So Then I'll just revisit in summary terms how the ouster has changed over time. I think really in the course of these submissions that has been addressed. So for all, across the history of these ousters, for all 14 prohibited grounds, the ouster provisions have they have remained materially identical in that it has always sought to exclude employees from claiming the detriment of dismissal. As I've covered already, there are only two situations in which that ouster has changed. Firstly, removing the Section 197 point, and secondly, introducing the requirement that the claimant is an employee in circumstances where the right has been extended to workers. And so that brings me to the position in relation to the 2013 changes, which the respondents rely upon as being a sea change. Now, the catalyst for these changes was the Court of Appeal's decision in the case of Fessett and NHS Manchester, which is at pages 671 onwards in your bundle, and is dealt with in the appellant's case from page 24 onwards. And the facts of that case are significant. The claimants in that case were nurses. They had made protected disclosures regarding the qualifications and clinical practice of another nurse who was effectively inflating the qualifications and experience that he was said to have had. And in response to having made that protected disclosure, the claimant nurses were subjected to unpleasant treatment, what we would describe as being bullying and harassment, by various colleagues. This included, as identified at page 676, paragraph 15, isolation and daily personal insults from their co-workers. It also resulted in an anonymous phone call threatening to burn down the house of one of the whistleblowing nurses unless she withdrew her complaint, which is at page 676, paragraph 15, and displaying her photograph on Facebook in circumstances that caused her distress, as recorded at paragraph 15 on the same page. Now, the Court of Appeal, notwithstanding the valiant attempts of the nurses and Protect, concluded that the employer could only be vicariously liable for the legal wrongs of its employees. And without primary liability, there could be no vicarious liability, as set out at page 680, paragraph 32. So Lord Justice Elias referred to the Madrevsky case in the Supreme Court, where Lord Nichols defined vicarious liability as a common law principle of strict no-fault liability, and noted that absent any legal wrong by the employee, there was simply no room for the doctrine to operate. So a lacuna in protection was identified. There were circumstances where a claimant who had been subjected to detriment caused by the claimant's protected disclosure but had no potential respondent against whom they could bring their claim. The claimant's claim was not that these were acts...
They had not been dismissed and they had not resigned.
My lady, you make an excellent point. The point I'm leading up to is this was not a dismissal case.
No.
This was a case effectively about bullying and harassment. And so the lacuna...
But if it had been if the nurses had said, right, enough is enough, I'm resigning, then the other nurses' behaviour would, I assume, have counted as the employer's conduct for the purposes of Section 95(1)(c, even though it was not conduct for which the employer would have been vicariously liable in a tortious sense, strictly speaking, but that employer's conduct giving rise to a constructive dismissal is, as I understand it, given a broader interpretation than was being discussed by the Court of Appeal in Fessett. Is that right?
Yes, I think that's right. The door would have been open to those nurses to bring a claim under Part 10 if they had resigned and claimed constructive dismissal based on the whistleblowing arising.
I mean, putting aside all the whistleblowing.
Yes. Well, whether with or without the whistleblowing.
Yes.
Yes. The door to Part 10 was open to them. So the point in Fessett was not a case where the lacuna was about the employees having nobody to sue in a dismissal situation. It was about they were not saying that the employer had instructed or encouraged or caused the co-workers to bully them, threaten to burn their house down, insult them, etc., etc. What they could not do is they could not hold the employer responsible for the acts that were the co-workers' acts. And so that's, we say, is the prism through which one should interpret what happens next in terms of the legislative changes. Now, there were 3 nurses in that case. 2 were employees, and one of the things that they were upset about was that they had been moved to a different walk-in centre, so they were moved to a different location. The third claimant was a person described as a bank worker, and one of the complaints that she made was that she no longer received any shifts after the protected disclosures. And unfortunately, neither in the Employment Appeal Tribunal, it appears that in the Employment Tribunal they didn't deal with any of these issues about does that amount to a termination of contract under Part 5 or is it a dismissal under Part 10? Is she an employee or is she a worker? That was simply not referred to. They dealt with it on a simple causation basis and concluded that protected disclosure was not the reason why she didn't receive any further shifts. And there was nothing in the appeal about the treatment of that third nurse, the bank worker, Mrs. Hughes. And that's apparent from page 678, paragraph 26 of the judgment, and also page 682, paragraph 42. So despite the arguments that the absence of the court in the Court of Appeal recognising vicarious liability for the acts of co-workers would discourage workers from making protected disclosures and would inadequately protect those who did make protected disclosures, Lord Justice Elias, who together with Lord Justice Mummery and Lord Justice Davis agreed that it was not open to read the additional wording to the section as the advocates in front of him requested, because it would go far beyond the legitimate role in construing legislation. He concluded that on one reading, it did mean that there was inadequate protection for whistleblowers, and if so, the remedy lay with Parliament. That's at page 686, paragraph 61. And in response to that, the Enterprise and Regulatory Reform Act included the provisions which we now see at section 47B 1A to 1E. And if we look at page 194, that deals with those provisions, we see 1A, having already said that a worker has a right not to be subjected to any detriment done by their employer, 1A says that a worker has a right not to be subjected to any detriment by any act or deliberate failure to act done by another worker of the employer's, of the worker's employer in the course of that other worker's employment. That's the co-worker provision that we're looking at. And then at 1B, it sets out that where the worker is subjected to detriment by anything done as mentioned in the subsection above, that thing is treated as also done by the worker's employer. And so what that means is that something that the co-worker has done, if done in the course of their employment, now becomes the employer's act or the employer's failure to act.
As well.
As well, yes, as well as an act that's directly theirs. Yeah. This becomes their act too. And we say that is particularly significant in terms of understanding how the ouster acts, because when assessing what amounts to dismissal, if one is to say that the act of a co-worker amounts to dismissal, and there is difficulty with that, but if one was to conclude that what a co-worker was doing was an act of dismissal, then by virtue of subsection 1B, that is the employer's act, treated as the employer's act, becomes the employer's act, and so is also excluded under subsection 2B. Now, these 2013 additions, you will see from this page, 194 and 195, they are immediately next to the ouster provision. Just for completeness, we see at 1C, it says that it's immaterial whether the thing is done with the knowledge of or approval of the worker's employer, i.e., it's treated as the employer's act, regardless of whether or not it's been done with their knowledge or approval. And it also provides for a reasonable steps defence for an employer.
So the employer can escape liability if he shows that he's done what was necessary
Exactly.
to prevent that act.
Yes, that's right.
But then 1E says if the worker escapes liability because they were following orders, then presumably what then? That the employer could still be liable under
1B.
subsection 1.
And also under subsection 1B, my lady.
Well, that was what I was wondering, because it's still a detriment. It's just not a detriment for which the worker is liable because of 1E.
So these provisions enable a worker, whistleblowing worker, to bring a claim directly against the co-worker, or to bring it directly against the employer on the basis of the co-worker's liability by virtue of the mechanism in 1B, or indeed to bring claims against both of them. And in respect of the co-worker, the employer has a way out, which is by reason of the reasonable steps defence. But there is also, under section 1E, a situation where if a worker, the co-worker, is not liable, the employer may still be liable under section 1B. Now, the main reason for referring to these provisions is to show the proximity to the ouster and what happened to the ouster. And what happened to the ouster was absolutely nothing. No amendment, no addition, no exclusion, no preamble, no carve-out. So the drafter of this legislation, as we know, knows how to do this. We've seen it in respect of section 197. We've seen these changes happen when the provisions providing protection to workers have been introduced. But in 2013, nothing changes. And even Lord Justice Underhill in Osipov, at paragraph 30 of his judgment, says, this ouster means the same before and after the introduction of the 2013 provisions. So there is no textual change, there is no textual basis for concluding that the introduction of these unique provisions, which we accept are unique, introducing co-worker liability, that the introduction of those does anything to change who is included and who is excluded in dealing with whether the door to Part 5 is open or whether the door to Part 10 is open. So I will just very briefly now deal with the fifth and final point in terms of the architecture, which is on remedy. And for that, I just want to refer, without stealing any of Mr. Leaper's thunder, to page 22 of the appellant's case, which is paragraphs 56 to 63 onwards. Very briefly, the remedy provisions carry out a similar and careful delineation between compensation for unfair dismissal and compensation for detriment, including capping provisions, which is consistent with the separation, the exclusive route that's given to either employees or workers under the ERA in respect of dismissal. So I'm drawing this together then in terms of submissions, having looked at those principles of statutory interpretation and looking at each of those in turn. In terms of the ordinary meaning of the words, the Court of Appeal in Wicked Vision, page 114, paragraph 35, rightly described that this is a disapplication or an ouster which is described in plain terms. I've already taken that to that provision at page 194. It establishes a very clear dividing line between dismissal claims which can only be brought by an employee under Part 10 and detriment claims that don't amount to a dismissal which can be brought under Part 5. The provision is replicated across all 14 prohibited grounds that have a similar delineation, which always shuts out employees from making Part 5 claims. The wholly unambiguous words used in section 47b, 2, namely, this section does not apply, not just that subsection 1 doesn't apply, which is the actions of the employer, but the entirety of the section doesn't apply, so long as what we're looking at is an employee and a dismissal, which means what it says in section 95 of the Employment Rights Act in terms of designating dismissal. So what the claimants, the respondents here before you, contend for is a sea change in the interpretation of this provision, and one which we say is wholly unwarranted by the language. Had Parliament wished to ensure that individuals, employees who wanted to sue their co-workers for the detriment of dismissal could do so, then they could have, they would and could, and certainly would have included the sort of preamble or qualification that we saw in relation to section 197 or indeed elsewhere. I would ask you to note that the respondent's submission that all that is excluded, is the employer's own act of dismissal is both confusing, not natural, not ordinary, and on its own account internally inconsistent. So they say at page 66 of the case, paragraphs 25 to 26 of that case, that for an employee's claim to be ousted from Part 5, it needs to be both the employer's own act of dismissal, and secondly, the employee's claim must be within the meaning of Part 10, which they say means the protected disclosure must be the sole or principal reason for the dismissal. So it's the legal claim rather than the dismissal. Now, dealing with what they say, and I appreciate I can only take this so far because it's their argument, and no doubt this is something that the court may wish to explore with them, but dealing with the employer's own act of dismissal, there are not two or more acts of dismissal. There is one act of dismissal. And that
act is either, here's the letter you're going, don't come back tomorrow, or it is the employee's resignation saying, I've had enough, I'm not coming back tomorrow.
Yes.
Not the acts of the co-worker that led to that resignation.
It is not.
So Parliament must have had in mind what's the archetypal situation this is dealing with. The employee makes a protective disclosure, everybody's horrible to them in various different ways, they may suffer loss at that stage, they may not get any overtime, they may be very upset and take time off sick, and then at a certain point they say, I've had enough, I'm not coming back. Or they say to the employer, you've got to do something about them because I can't stand this. And the employer says, no, I'm not going to do anything. You've brought it on yourself. And then the employee resigns. So how then does it, taking me through those different kinds of loss, so then they resign, now they haven't got a job, so they've lost their earnings going forward.
Yes.
So how does that typical situation that these provisions must have been designed to deal with,
yes,
how does that work? What claims can you bring in relation to what loss can you claim?
Yes.
For that?
My lady, those are excellent points, and those are Mr. Leaper's points.
Okay.
And if I might say, I only have 5 minutes remaining, so I do hope you won't hold it against me if I don't go into that now.
No. Can I just add to it while it's in my mind?
Yes.
Lady Rose asks you about that hypothetical scenario. Can Mr. Leaper also deal with the course of harassment that leads to the employee being sick, unwell for months, maybe a year, but doesn't resign, but eventually the employer decides to dismiss them because they've been absent for
Yes.
such a long time.
Yes, and I know that he is going to address that very point. Now, so, as I say, dealing with the employer's own act of dismissal, there aren't two or more acts of dismissal under the Employment Rights Act, one carried out by an employer, one carried out by a co-worker. There's no situation where one turns up and says, I was dismissed by my co-worker, and they don't mean that they were dismissed by their employer. And the Employment Rights Act has provided this prescriptive and detailed code, including those provisions that I took you to on Section 95 and 96 in Part 10. It descends into considerable detail, as we saw in Section 43K and Section 230. But effectively, what the respondents is saying is that from 2013 there is some new exempt category of dismissal by a co-worker which remains at large, not defined within the Employment Rights Act, and no guide to what is included in this brave new world of legislation. And we say that that does not bear scrutiny. As to the second condition, they say that unless the employee's claim is a claim that it was for the reason or principal reason for the dismissal was whistleblowing, then the ouster from Part 5 does not apply. So what that means is Section 47B2 and all the equivalent ousters, Section 47B2, because this is the one that deals with co-workers, is a dead letter and has always been. Because if all that one needs to say is, oh, well, hang on a minute, I don't actually mean a dismissal that gets you to that high bar of reason or principal reason for the dismissal as protected disclosure, I'm just talking about the low bar claim, then it always got under the low bar, and it wouldn't even exclude the employer's own liability under Section 47B1, and we say that does not make sense. And it particularly does not make sense and is internally inconsistent with Section 25 of the Respondent's case at page 66, where they say that 47B2 was subject to the second condition, and this is a direct quote, to prevent an employee bringing a claim under Part 5 against the employer in respect of the employer's own dismissal, where Part 10 provided the appropriate and exclusive route. So in other words, what they're seeking to do is recognise at that stage that the Part 10 door was closed. We say the Part 10 door is closed for all employees in that situation. I very quickly make the final three submissions. I said at the outset it's so important to consider this in the context not just of the provisions as they look now, but also in the historical context. I won't descend into further detail on that. In terms of the purpose of the legislation, one needs to see what FESIT was designed to, the situation in FESIT that caused Parliament to make the changes that led to 47B1A through to 1E. It filled that gap. It did not go further than that and deal with dismissals by co-workers. And in particular, insolvency or concerns about insolvency were no part of the FESIT picture. We have no Hansard in support of this provision. We have no consultation paper in support of this provision to say that this was about insolvency. And the Act already provides for limited routes in respect of the rights of employees in situations of insolvency, and that reflects Parliament's intention. We say that absent the ouster, if you were to read the provision in the way that the respondents do, it would lead to incoherence, meaning that employees could bring claims under both parts, when we see what Parliament has so carefully sought to do over the past 30 years is to keep those distinct and mutually exclusive. And finally, in relation to the constitutional imperative that citizens need to be able to understand the legislation that's in front of them so they can decide whether to bring a claim, or so that advisors can give proper advice to decide whether claims should be brought or indeed claims should be defended, and how one should conduct oneself. In our submission, putting oneself into the shoes of a layperson, a citizens' advice bureau advisor, a business person, somebody without a sophisticated legal team or HR department should be able to tell and can tell from this legislation, in my respectful submission, what that ouster covers and what it does not. And in reality, what it covers is what Lord Justice Elias pithily described as detriment short of dismissal, as set out at page 674 of the Fessett judgment, paragraphs 7 to 8. That doesn't require the conceptual gymnastics of the employer's own act, a co-worker's undefined separate act of dismissal, and the sidestepping of liability that the respondent contends for. In reality, both before the day that these 2013 changes came in and afterwards, the ouster had the same meaning. And if there if there truly is an absurdity in the legislation, and we say there certainly is not, these are reflected of Parliament's intentions over the past 30 years, then it is a matter for Parliament to legislate in respect of this and not for the courts. In truth, most of the matters that the claimants, the respondents in this case, take aim at are a consequence of the differing causation tests between Part 10 and Part 5 and a wish to sidestep those matters. Unless I can assist further, I will hand over to Mr. Leaper.
Yes, thank you very much, Ms. Matraghi. Yes, Mr. Leaper.
My lords, my ladies, I'm going to address you on four matters. Firstly, the different remedies under Parts 5 and 10, and take you through the statutory scheme, and luckily dealing only with the present statutory scheme, not going into the history. Secondly, to address fairly briefly the alternative ground that Barton turns advances in relation to the construction of 47B2. Thirdly, to make some submissions in relation to prevents submissions. And fourthly, to deal with the joint ground of appeal on precedent. I should say that I will deal with the points that have been raised, particularly by Lady Rose and Lady Simler, in the course of my submissions. I will turn to those. So firstly, then, dealing with the remedies under Parts 5 and 10. I don't understand there to be a difference between the parties on this, but it is important to understand the overlap and the difference between the two remedial regimes. So Part 5, if we look at that first, and within the main bundle, may I ask you to look, please, at page 251. So this is the starting point. You've shown that you've blown the whistle. You've shown that you, or you want to make a claim that you've been subjected to a detriment. And the complaint is brought under Section 48, and of the various provisions that there are, it is 1A, which relates to Section 47B. So a worker may present a complaint to an employment tribunal that he's been subjected to a detriment in contravention of Section 47B. So each of the provisions varies slightly on whether the wording is employee or worker, and in one specific instance, a person, because there's a wider definition of employee in the Tax Credits Act. That's 1B. Then over the page, subsection 2, on a complaint under the provision we're dealing with, it is for the employer to show the ground on which any act or deliberate failure to act was done. 3, an employment tribunal shall not consider a complaint under this section unless it is presented within 3 months, essentially, and then there's a discretion for a period which the tribunal considers reasonable, if it's not reasonably practicable. But the essential limitation period is 3 months.
Sorry, can you just go back to subsection 2?
Of course.
So on a 1A or a 1B complaint, where you're saying it's a co-worker who is the primary victimiser, it's still for the employer to show.
In that instance, it would be, and I'm about to take you to this, it would be construed as the co-worker. So if you look at subsection 5, in this section and section 49, any reference to the employer includes B, in the case of proceedings against a worker, the worker or agent. So it would still be the same onus, but the onus would be on the co-worker because the claim was against the co-worker.
Thank you.
What then if you succeed on your complaint? Then you have remedies under section 49, that's at page 254. Firstly, subsection 1A, a declaration, and then B, an award of compensation. Under subsection 2, still 254, the amount of compensation awarded shall be such as the tribunal considers just and equitable in all of the circumstances, having regard to the infringement and any loss which is attributable to the act or failure to act which infringe the complainant's right. That's been addressed in Donaci. That doesn't give an open-ended approach for a tribunal. It is still to apply appropriate causation test. Under 4, to note, the individual has duty to mitigate, and 5 can be a deduction for causing or contributing to the dismissal. And then under 6A, there can also be a deduction if the tribunal finds that the protected disclosure was not made in good faith. Now, there's a critical provision I've missed out, which is subsection 6. Where the complaint is made in a whistleblowing case and the detriment to which the worker is subjected is the termination of his contract and that contract is not a contract of employment, any compensation must not exceed the compensation that would be payable under Chapter 2 of Part 10 if the worker had been an employee and had been dismissed for the reasons specified in Section 103A. So, in short, if it is a case of a worker who brings the claim rather than the employee, and it relates to termination, then the worker on that claim cannot recover more than he or she would recover under the dismissal remedy provisions. So it's essentially a capping provision, which means that the worker claimant cannot get more than the employee claimant could.
And just to be clear, was that provision in those terms when there was a cap on the compensation that could be awarded for unfair dismissal?
I believe it was. So that cap...
That makes sense.
It does. The cap is going to be removed.
At this point?
In January of 27 is the intention, as I understand it. So there is going to be a removal of the capping provision, but the overall capping provision, which I will come to, this particular provision isn't being repealed. No. So that this provision remains in place to assure that there is alignment between the worker and the employee, one terminated, one dismissed, whether or not the cap is there at all. So that suggests, in our submission, that Parliament's not intending, or wasn't intending, for it only to deal with the 124 cap.
Sorry, could you repeat that? Parliament wasn't intending?
Was not intending that the sole function of this provision related to the fact that there was a cap on awards for unfair dismissal in all cases, but that was subsequently removed for whistleblowing cases. So there is no overall cap for an employee in a whistleblowing case.
So, but is it fair to say when it was first introduced, the sole purpose was to ensure that you couldn't recover more than the capped award you could have recovered?
I can't say that's right with respect.
You can't say that.
Because What it does is it aligns the compensation, the maximum compensation, for both worker and employee. Now, an obvious reason for that was that there was a cap on what an employee could recover. But it means that there is an alignment between the payments that can be paid by way of compensation to the worker and to the employee. I can't say that that was the sole reason why it was introduced at the time. If it were the sole reason, why is it not being removed at this point when the cap in all cases for employees is about to be removed?
But is the cap a sort of a figure,
Yeah.
a pounds figure?
In a moment, I'll take you to the unfair dismissal provision, and that will become crystal clear. Now, I'll move. Obviously, there can also be an award for injury to feelings on this award. Now, if I take you now to Part 10, and that is at page 1887. Sorry, if we start at 1884 to make it a parallel exercise. So section 111, this is where you bring your complaint to the employment tribunal. So 111, a complaint may be presented to an employment tribunal against an employer by any person that he was unfairly dismissed. 2, you have a time limit, again, a limitation period, and that is 3 months. But that is 3 months beginning with the effective date of termination. Now, in the case of an employee who is given notice of termination, say 6 months, the unfair dismissal claim must be brought within 3 months of the end of the notice period, not the giving of dismissal. So there's, in some cases, obviously not in a summary dismissal case, in some cases, the effect of this is to give a longer time for an employee to present their claim of unfair dismissal. And the effective date of termination, for your note, is at section 97, page 1868. Moving on to section 112.
Sorry, and if it was a constructive dismissal, time would run from the date of the resignation.
Assuming that the employee gives no notice,
Yes.
which is the
Yes,
normal
yes.
case, but it is possible to say, well, I'll leave in a week.
I'll leave. I'm so dissatisfied, but I'll stay for a minute.
I've seen it, I'm afraid, peculiar as it may be. Then, 1887, the remedies. This section applies where the tribunal finds that the grounds of complaint are well-founded, and then there's a structure. Orders can be made under section 113, and then if no order is made under 113, the tribunal may make an award of compensation. So we have to work through the structure that there is. Section 113, page 1889. The orders that are referred to there are orders either for reinstatement, that is, you can go back to exactly the same job, or for re-engagement, which is you can go back to a broadly similar job which we accept is comparable.
And just to be clear, those are quite valuable orders because the employer is then required to pay all the salary that
Absolutely.
flows, that's been lost between the date of the termination and the date of the reinstatement or re-engagement.
That's absolutely right. They are remedies of significant value to an employee. I don't know if there are statistics on how often they are actually applied, but the idea of it is there. And of course, if an order is made for reinstatement or re-engagement and the employer fails to comply with that order, then a certain additional fixed sum is due to the employee. Section 114 deals with an order for reinstatement, 115 an order for re-engagement, 116 choice of order and its terms, enforcement of an order and compensation, that's where you get the fixed sum I referred to. So all of those provisions deal with something other than compensation, although filling in the gap when they weren't being paid is part of that. Then you get to 1898, which is the provisions on compensation. Compensation involves a basic award and a compensatory award. The basic award is based on a week's pay, which has a statutory definition and is capped for this purpose, multiplied by a multiplier based on the number of years worked and the age of the employee. It is a significant sum for a low-paid employee. Because of the cap on a week's pay, it quickly becomes less significant for higher-paid workers or employees. The compensatory award is dealt with under section 123, which is at 1906. And the wording of 1231, again, is such amount as the tribunal considers just and equitable in all the circumstances having regard to the loss sustained by the complainant in consequence of the dismissal insofar as the loss is attributable to action taken by the employer. So language that mirrors that we saw under Part 5. Then there are provisions on mitigation caused or contributed and in whistleblowing cases where the disclosure is not made in good faith. The limit on the compensatory award is found in section 124, and that provides that the limit of the amount of any compensation awarded shall not exceed the amount specified in the next subsection, which certainly at the time of printing this was 123,543, or 52 multiplied by a week's pay of the person concerned, whichever is the lower. So no, on an ordinary unfair dismissal claim, no employee can recover more than £123,500, whatever their losses. However, under subsection 1A, that does not apply only in very limited circumstances, one of which is a whistleblowing case.
And can you just remind us when the 1A provision was introduced?
It was in 1999.
99.
Now, one other provision, Lady Simler referred to the overlap in discrimination cases and how there wouldn't be an overlap in compensation. That is, of course, right, but it is dealt with specifically by a provision, which is at page 1911, section 126. This section applies where compensation falls to be awarded in respect of any act, both under the provisions of this Act relating to unfair dismissal and the Equality Act. And effectively, subsection 2 is a deduplication of compensation. So, yes, there isn't an overlap of compensation, but there is specific statutory provision which makes for that. And as an aside, there is no specific statutory provision. So it's 126 subsection 2 on page 1911. There is no similar provision saying that there can't be an overlap between an award under Part 5 and Part 10. And we say the reason for that is because you can't have an award under both. The other valuable claim that a dismissed employee has, or the remedy, is an application for interim relief under Section 128. And in short, a dismissed employee can make an application to the tribunal within 7 days of their dismissal and ask for an award which provides them either with a continuation of their employment or with compensation up until the date of the hearing, which under the current tribunal system can be a considerable time. So it's a very valuable remedy. But the test for getting it is high. It's not an easy test. It applies in whistleblowing cases, but it is not easy to succeed on that application. Under section 129 on page 1914, the question is whether it is likely that the individual will succeed, but likely has been interpreted as meaning a significantly higher degree of likelihood than more than likely than not.
Because the assumption is you won't get the money back if they...
That's right, yes. So you've got to show, and it does happen, and it happens quite regularly, and the number of applications are increasing quite significantly particularly because of the delay of getting a resolution for the final hearing. But it can be a significant benefit to the dismissed employee, not something that's available to the terminated worker. But to be clear, we're talking about whistleblowing cases. This is not generally available to any dismissed employee. Now, one important aspect is how do the awards fit together? So, in Melia, Lord Justice Chadwick made the point, for your note, paragraph 21, page 1030. He said this: "It's clear, therefore, that in a case where compensation is to be awarded under Part 10, it is limited to compensation for loss sustained in consequence of the dismissal. It will not include compensation for loss sustained prior to the dismissal. Loss sustained prior to the dismissal cannot be loss sustained in consequence of the dismissal. That is an important feature to keep in mind when considering the interrelationship between compensation under Section 49 for a detriment and compensation that can be awarded under Part 10. One other feature, it has been established, in the lower courts at least, that in principle pre-dismissal detriments may cause recoverable losses which post-date a dismissal, subject to questions of remoteness and causation. And for that, there's the judgment of Lord Justice Singh in Roberts and Wilson's Solicitors, and that is paragraphs 87 to 91 at page 1307. Lady Justice Hallett and Lord Justice Longmore agreed with Lord Justice Singh. That's at page 1309. So, a pre-dismissal detriment can have post-dismissal effects which can be recoverable. A dismissal can only have future losses, not past losses. Now, a worker...
Is that a general rule, or is that a rule because of the need to work out how these fit together?
Well, it's certainly a general rule that an employee can only get compensation from the point of dismissal in relation to their dismissal.
Yes.
I think that where there had been an area of doubt is whether a pre-dismissal detriment stopped at the point of dismissal, whether you could not recover any losses past that. And that has been resolved, at least in the Court of Appeal in Roberts and Wilson's Solicitors. Now, this question, going back, if I may, just to this question of the employee, an employee does not have the provision that there exists in relation to a worker for there to be this capping in line with Part 10. So the Part 5, it's the worker to whom the cap applies. It is not the employee. There is no equivalent provision for an employee. Now, that is not, in the word of Lord Justice Underhill in Timis, just another wrinkle in the statutory scheme. It's important because it means that there is a clear indication that it was never and still is not the intention that an employee could recover in relation to their dismissal under Part 5, because there is no provision which says you can't recover more than you could under Part 10. The overarching structure of the Act shows that that was never the intention. And had Parliament intended to allow employee dismissal cases to be brought under Part 5, it would have introduced a correlative provision as there are for workers' termination claims. Let me turn, if I may, to the alternative Barton turns ground. It's a refinement of the position which has been explained to you by my learned friend, which we adopt completely. But there is an alternative. We argue in that alternative that properly construed, Section 47B(2) disapplies any claim under 47B(1), 1A, or 2, where the employee has a potential claim under Part 10, that is, a claim which could lead to a remedy under Part 10. Now, on that approach, we say that if there cannot be a Part 10 claim, even though there's been a dismissal, for whatever reason, then the employee can rely on Part 5 because 47B(2) does not apply. So 47B(2) doesn't kick in simply because there is a dismissal. There must be a possibility of a Part 10 claim. So in the statutory language, it must amount to a dismissal within the meaning of Part 10, dismissal for which there is a claim under Part 10. The primary construction that my learned friend has explained to you is that this means a dismissal as defined within Part 10. That's it. The alternative is that it means a dismissal allowing a claim and so engaging this distinct remedial regime within Part 10. Now, that construction is intended to and would deal with the case where the employee can't sue their employer, for example, because they're in administration. They have no effective claim under Part 10. So rather than being left with nothing, they can bring a claim under Part 5, but only in those unusual circumstances where they cannot bring a claim to achieve a remedy under Part 10. We say that that is consistent with the orthodox position explained by the Court of Appeal in Melia, and that was, and it's been referred to before, paragraph 15, Parliament did not intend to confer a right under Part 5 for the protection of whistleblowers in circumstances where the worker, being an employee, would have a right under Part 10 of that Act in relation to the same loss. So the focus here is on the different remedial regimes. There's no dispute that the regimes do differ, but on this alternative construction, if the employee does not have a right under Part 10 in relation to his dismissal to pursue the four unique aspects of that regime, an application for interim relief, a declaration of unfair dismissal, reinstatement or re-engagement, compensation in its two forms, then if he can't do that, he's free to seek to recover his losses under Part 5.
Your example is a rather odd one because the employer going into administration, I can see that it means that there's no point pursuing your right, but you say that falls within the context of, or that would be a circumstance in which there is no right under Part 10.
Well, the statutory moratorium would apply under the Insolvency Act 1986, yes. So there would be a bar on pursuing proceedings against the employer. If you tried to issue a claim, then the employment tribunal would say, we can't entertain this claim because the moratorium is in place. So in that instance, it's not just that there's going to be an ineffective remedy, it's that they can't pursue the claim. They're debarred from doing it. So, as I say, these are rare instances, but the norm is that you're going to be able to sue your employer for unfair dismissal, and therefore your claim falls within Part 10. So, the two particular instances that were put. Firstly, constructive dismissal. Constructive dismissal is the act of resigning in response to a repudiatory breach. It's the acceptance of the prior repudiatory breach of the employer. In that case, it will be necessary to consider what was the reason for the dismissal, what was the employer's reason for the dismissal. And that's going to require an examination of the minds of the individuals, because the employer only ever operates through the minds of individuals. Where there is conduct over a period,
the minds of the
individuals
in victimising the...
In that example, yes. Yes. Because it is the conduct which the employee has been entitled to rely on in order to say, I am dismissed, I can resign, and it's a repudiatory breach. So look to the circumstance of the repudiatory breach, look into the minds of the individuals who undertook that conduct. But in this instance, that conduct itself could include claims against the co-workers. So the claim under Part 10 is for the dismissal, the termination, at the end of the period of conduct. That is where your dismissal claim comes in. You may have freestanding detriment claims for the course of conduct that led to it. And to an extent, there's an overlap in looking at the minds because it's likely to involve the same individual.
Well, claims against who?
The perpetrators of the conduct which amounted to repudiation.
But the only value in that sort of a claim would be injury to feelings if you also had a dismissal.
That's right,
So
or you would have the rare situation where the employer has no money, but the employees do, co-workers.
But assuming you could resign at the end of it, you're saying you could claim under Part 10 and get all the remedies,
yes,
but also claim under Part 5 for the freestanding detriments that precede the dismissal,
yes,
and get the injury to feelings award.
But you can do that in any dismissal case.
Yes.
If there is there are pre-dismissal detriments, and then there is a dismissal, you can always bring a claim for the pre-dismissal detriments against a co-worker. It is only the act of dismissal, and this is no different. The fact that the conduct involved is likely to overlap doesn't distinguish the legal analysis. You have still got a termination at the end of it by reason of the employee's resignation.
But the employer is vicariously liable for that whole course of conduct.
Yes.
Yeah.
Pre-dismissal course of conduct.
Pre-dismissal.
So in the situation it was envisaging, the resignation is the cut-off date. You say all future loss from the constructive dismissal is recoverable under 103A only from the employer. And there the words employer's conduct includes all the nastiness beforehand from the fellow employees. But if there was loss before the resignation arising out of that same conduct, injury to feelings, or there might have been loss of earnings,
or sickness,
they could claim that against the co-worker and claim that the employer is vicariously liable for that.
Yes. Then you have the further twist on this, which is that the employer, so we move from a constructive dismissal case to a dismissal case, and this is the example posited by my Lady Simler, which is that the individual is subjected to such awful harassment that they go off on long-term sick. And at the end of that, the employer dismisses them fairly because they're away from work through ill health and are unlikely to return to work, and they go through the proper processes in relation to that, and then they are dismissed fairly. Now, that means that the individual gets no rights on their dismissal because they've been fairly dismissed. They get no compensation, they're given notice, that's an end of it. Now, the question that's posited is there a claim before that in relation to the course of harassments that they were subjected to by the co-workers? And the answer to that is yes. And that's why I took you a few minutes ago to the case of Roberts and Wilson's, because there is authority which says that you can recover for the losses that arise from a detriment, even if they post-date the dismissal, subject always to questions of causation and remoteness. The individual in this case would say, well, it was inevitable that I was going to go off sick and I'd be fairly dismissed. So that can't be some sort of new intervening act which prevents me recovering my loss. I can recover my loss from the co-workers as a result of the course of harassment that I was subjected to by them. And this is an example that was...
And you could hold the employer vicariously liable?
Yes. Subject to the employer saying, well, we took all reasonable steps.
Yes, of course. Yes.
But in principle, that's of course right.
And that individual would recover injury to feelings as well. He wouldn't have any of the
no, that's exactly
the unfair
right.
dismissal remedies, but he'd have
exactly right.
all the detriment remedies under Part 5.
Now, the respondent's case suggests that there is confusion. I suggest there isn't. And this is at page 74, paragraph 52 of the respondent's case. And they say, if an employee is subjected to a detriment because they have made a protected disclosure, resign and claim constructive dismissal, the employee would argue that it is the detriment which has caused the future loss of earnings, and they can bring a claim under section 47B 1A and 1B. However, the co-worker and employer would argue that it's the dismissal, and the claim can only be under Part 10. For the reasons I've explained, that this isn't a confusing situation. It depends on the circumstances leading to the constructive dismissal. It depends on the circumstances of the dismissal. There is a clear, structured, logical delineation about who the claim can be brought against and against whom the losses can be recovered.
So what you're objecting to really is this idea that absent any misconduct by the co-workers, all there is in fact is the employer dismissing. I mean, take a different case. Nobody knows about, none of the co-workers know that the employee has whistleblown, but the employer knows. And the employer says, you can't stay, you've got to go, we'll give some excuse to your co-workers, but you mustn't come back.
Yes.
But the letter dismissing them is emailed or posted to them by one of their co-workers. And the question is that then a detriment imposed both by the employer and by that?
And that would be an argument that could be had, and it depends on the facts of the situation, yes.
But I thought that was absolutely the case in which you say that is barred by 47B2.
Well, it depends on the circumstances in which, if the detriment is the sending of the letter, it depends whether that can be identified as a detriment that is separate from the dismissal or is wrapped up in the dismissal. The sending of the letter, it depends exactly what the circumstances are. If it is merely an individual sending a letter which communicates the termination, then that is part of the termination. And yes, you're absolutely right. Our position is that is clearly only a Part 10 case.
Yes, and the added complication of all this, the duty manipulated decisions is an area of complexity that we might not have to get into.
No, I would suggest that it's important because it shows the complexion of these types of case, which is that when you're looking at the act of dismissal, as a result of this court's decision in duty, one is looking at the minds of not simply the dismissing manager, but also someone who is involved in the dismissal process or someone who has manipulated the process. So it means that there is a broader access to understanding whether there has been a whistleblowing dismissal, because you're not confined to looking at the individual dismissing officer in appropriate cases. So yes, you're forced into a Part 10 claim, but that is not as constricted as is being suggested, because you're not looking simply at one individual's mindset who might have no awareness of the protected disclosure at all. You can look at the mindset of someone who has manipulated the situation so that the dismissal is almost inevitable.
But on what you said a moment ago, Mr. Leaper, wouldn't you then have a Part 10 claim against the dismissing manager, for whom the employer is the proper respondent, but also a Part 5 detriment claim against the manipulating manager for acts of manipulation?
Yes, you might. Yes, you might. But those are for prior detrimental action.
Well, for manipulating the manager, and in that situation you may fail in your Part 10 claim against the employer and the dismissing manager, but you may succeed in your Part 5 detriment claim and recover exactly the same future losses.
You might.
Right. You accept that?
You might.
So you could
do that. But it depends on the circumstances, inevitably. But it's not ruled out. Because if you can analyse what the manipulative individual did as a detriment, and you bring your claim in time, then that you have a freestanding claim in relation to that detriment. And that is it depends on whether that is only analysed as part of the dismissal or whether it is a pre-dismissal matter. That is why I suggest that the Johnson exclusion zone, which I know has been dismissed at various points.
I was going to ask you about that.
But all I'm relying upon it is by way of analogy. It's not it trying to import common law concepts. It is simply saying courts and tribunals are well used to determining what is a dismissal and what is a pre-dismissal act, because it has had to do it because of the Johnson exclusion zone. Yeah. And it is exactly the same in this scenario. There has to be an analysis of whether the act that is complained of is the dismissal or whether it is a pre-dismissal matter, pre-dismissal detriment. So it is only that analogy that I rely on Johnson and Unisys. But by the way, Johnson and Unisys contains a very valuable description by Lord Hoffman of the history of the origins of unfair dismissal, the unfair dismissal proceedings from the 60s onwards. I'm very much out of time, but let me deal briefly, if I may, with a couple of points in relation to protect. Firstly, the statutory context. There's some suggestion in Ms. Raphael's witness statement is that the placement of the whistleblowing material within the wider employment rights corpus is a matter of convenience rather than necessarily theoretical affinity. We suggest that can't be right. There was a choice as to whether this was put within the Employment Rights Act, the Equality Act, or in a freestanding act, and that was a parliamentary choice, and it was put within the framework of the Employment Rights Act, and that includes other important protections. One example of that is for the protection that's afforded to jurors, those undertaking jury service. There can be no doubt, to give a specific example, that a juror who is subjected to a detriment need only show that the jury service was a material influence on the decision, whereas if the juror is dismissed, she must show that it is the principal reason. So this causation point is embedded in the protections that are afforded within Part 5 and Part 10. It's difficult to see why a juror gets a different form of protection than someone who blows the whistle. There is an equal public interest in both. So that emphasises that these differences are embedded within the structure and were not sought to be departed from in relation to whistleblowing. The other result of the arguments of Protect under Section 47B2 is that 47B2 is said not to exclude even a claim against the employer under 47B1, the direct detriment claim against the employer. Protect say that that is not precluded or ousted by 47B2. That has the consequence that the language of that provision, 47B2, has to be given a different interpretation than the other cognate provisions in Part 5, and that is expressly protects position. But that is something that can be done only very rarely, and generally where it is clear that there is a genuine drafting error. That is for Women Scotland, paragraph 176, page 796. The Court of Appeal in the present case made the same point, paragraph 72, page 123. The critical problem with Protect's approach is that its interpretation gives no meaning at all to the phrase, this section does not apply. And that is untenable because it does not respect the statutory language. Lastly, let me look briefly at the question of precedent.
It's a matter for you, Mr. Leaper, but I should point out you're eating very deeply into your reply time. It's a matter for you whether you want to address us on this or leave us with your written submission.
On the question of precedent, I'm very happy to leave you with the submissions that we've made in our written case. Those are submissions made jointly on behalf of all the appellants. I'm very happy to step down at that point.
Thank you very much, Mr. Leaper. Yes, Mr. Sullivan.
Thank you, my Lord. This appeal is essentially a short point of statutory construction, but as you've heard, it has significant implications for the practical protection of whistleblowers. The appellant's case is that the ERA provides a rigid one route only rule. So if the detriment suffered is dismissal, the employee must proceed only under Part 10 and hasn't got a claim under Part 5. That seemed to be narrowed as the submissions went on. And we heard from Mr. Leaper just now that there is a paper-thin distinction, actually, between a decision to dismiss and the dismissal. We say that doesn't exist at all. And in fact, in the Court of Appeal, as you will see when both I and Mr. Jupp make submissions, the Court of Appeal accepted or asserted that there was no distinction between a co-worker's act and the employer's act. And that seems to be abandoned now by the appellants. But we say, in any event, for a whole series of reasons, the appellant's submission is wrong. It elevates a feature of the Employment Rights Act, namely that there are separate parts for detriment and unfair dismissal, and makes it a point of principle which is wrong. It does not answer the unique issue raised in the 2013 amendments. Our answer is this. First, Section 47B2, as you've seen at page 195 of the bundle, was designed to prevent an employee from bringing under Part 5 a claim against the employer for the employer's own act of dismissing the employee, where Part 10 provides the only route. It doesn't prevent a claim of detriment against a co-worker, which we say can never be a dismissal, because only the employer can dismiss. And you've been shown Section 95, page 1866 of the bundle, which makes clear in express terms that dismissal is an employer's act. We say the appellant's construction deprives the words in the subsection within the meaning of Part 10 of any meaning at all. Secondly, the 2013 amendments created a different form of liability that's unique in the ERA, personal liability of co-workers and vicarious liability for that liability for the employer. And thirdly, the flip side of that is that nowhere in the ERA is there an equivalent claim against a co-worker, and 103A, the unfair dismissal claim for blowing the whistle, in Part 10 doesn't replicate the causes of actions created by 47B 1A and 1B. And finally, the appellant's construction strips the 2013 amendments of the effect in the very cases where protection is most needed, namely where a co-worker victimises a whistleblower by bringing about dismissal, which normally causes the most significant detriment. So Mr. Jupp and I will address the court on behalf of our respective clients. We will, obviously, it's effectively one appeal and one response, but we'll split up our response as Ms. Montraghi and Mr. Leaper did. I'm going to deal with construction. I'm going to address the court on the architecture of the ERA and the background to the 2013 amendments. Secondly, the meaning of and effect of 47B2 in the context of co-worker provisions. And thirdly, in the context of construction, the anomalies and what we say are absurdities which would occur if the appellant's construction is preferred. Mr. Jupp will address the different forms of liability in section 47B and the practical operation of 47B2 and the equivalent provisions in part 5. So we'll hopefully give the court discrete submissions. Firstly, the statutory architecture of the ERA. You've heard from Ms. Montraghi that the appellants place substantial weight on the distinction between Part 5 and Part 10. And Part 5 is concerned with detriment, and Part 10 with dismissal, with all the suite of remedies in Part 10 which fall on the employer only, like, for example, interim relief, reinstatement or re-engagement, and a basic award calculable from the start of employment, which only the employer can provide and be liable for. And the appellants identify a general pattern, which is correct in general, that across Part 5, detriment provisions are commonly disapplied where the worker is an employee and the detriment amounts to a dismissal within the meaning of Part 10. We don't deny the general pattern, but we say the error that the appellants fall into is to treat that pattern as conclusive even after Parliament introduced into section 47B a liability that exists nowhere else in Part 5. In the appellant's case, page 21 of the bundle, paragraph 17, the appellants say Part 5 prohibit an employer from subjecting a worker to a detriment on 14 prescribed grounds. We say that's wrong, or at least it's materially incomplete as regards 47B, which also prohibits a co-worker from subjecting a whistleblower to a detriment. And 47B isn't simply another employer detriment provision, because as you've heard when you were taken through the legislation, it provides for primary liability of a co-worker under 1A, vicarious liability for that primary co-worker's liability for the employer, and a statutory reasonable steps defence, which is similar to provisions in the Equality Act. And those provisions apply even where the detriment in question can have a contractual origin. So only the employer is a counterparty to the employee's contract, but you can bring a detriment claim against a co-worker for example, subjecting you to the detriment of suspension or demotion or varying your contractual terms. And in those circumstances, you can have a claim against both a co-worker under Section 1A and directly against the employer for direct liability under Section 47, capital B1, potentially in respect to the same detriment.
And how would the tribunal deal with compensation in that situation? Because there's no statutory provision that deals with double recovery.
No. It would...
Would it deal with it with
in normal tortious terms of there being no double recovery. That's not complicated. And it's often dealing with cases where the claimant has a claim that could result in a remedy which is identical under different statutes. And you've seen, for example, in a discrimination claim and an employment claim, you can have...
But there's a statutory provision there.
There is a statutory
I'm asking
provision.
you this question because there's
It's just normal tortious principles would apply.
Well, how does that work? How does it work? You get a basic award and you get compensation.
No. These are for
under Part 10. Yeah.
These are for I'm talking about detriments, my lord.
Right.
But sorry, I can ask a different question.
Well, I was asking about how the two awards were set together. If you were succeeded under Part 5 and Part 10.
Yes. So you wouldn't get double recovery. Okay. So you'd get an injury, potentially an injury to feelings award under Part 5 for dismissal, a detriment amounting to a dismissal, and you would get other remedies that are peculiar to Part 10, like a basic award. But and a basic award isn't a compensatory provision. It's a statutory provision which is intended to provide some form of compensation for loss of employment. But you don't set it off against other losses. So it's just another form of loss that you can recover. But you wouldn't get the same you wouldn't get double recovery of the future loss claim if you've lost earnings.
And on the example that you were giving, where it was a Part 5 claim with primary liability against the co-worker, vicarious liability against the employer, is it joint and several liability, and the tribunal will work it out?
Yes, well, yes, it would be. And there's primary liability also against the employer, my lady.
Yes.
And vicarious liability for the employer.
Yes, sorry.
Yes, it's joint and several, and the employee doesn't have to bring a claim against any of those, or all of those parties. It could just bring a claim against one of them.
But if he does?
If he does, then it's joint and several. So we say that undermines the appellant's contention there's only one route to remedy under the ERA.
Can I ask you a basic question that's just occurred to me? 47B1 tells us that a worker has the right not to be subjected to any detriment by any act by his employer done on the ground that the worker has made a protective disclosure. Is there any right not to be subjected to detriment by co-workers?
I'm sorry, I didn't hear you.
Is there any right not to be subjected to detriment by co-workers?
Under 47B? Yes. That's 1A.
Oh, yes, I see.
So that is my lord, that is the amendment that was introduced in 2013.
Fine.
But your point is there are lots of non-dismissal detriments that can actually only be made by the employer because the employer is the only other party to the contract of employment, or such as suspension or refuse to vary the terms or something. But there's not been any problem with treating that as something which is done by the co-worker.
Exactly. And we would say exactly the same point applies to a dismissal as well. So the distinction my learned friend was trying to draw, my learned friend Mr. Leeper was trying to draw between a decision to dismiss and the dismiss is a distinction without a difference. And we say it completely undermines the basis of the appellant's case, that there's no difference between well, the Court of Appeal said there's no difference between a co-worker's decision to dismiss and the employer's dismissal. And we say that's wrong. There is a legal distinction because they're separate legal personalities. And the distinction or the difference between a claim against a co-worker and a claim against an employer is perfectly tenable and happens the whole time for pre-dismissal claims under Part 5. And that's the point we're making. So in the few minutes I've got before lunch, may I address the court on the case of Fetch It, if that's how to pronounce it, and the reasons for the amendment, because that will impact, we say, on the way in which this court should construe the amendments and the effect it has. So you've been shown the case of Fetch It briefly. That case, as Ms Montraghi correctly explained to the court, exposed a gap because as it then stood, 47B meant that an employer could not be vicariously liable for detrimental treatment by a co-worker where the employer hadn't subjected the employees to a detriment themselves. So my Lady Rose asked a question, I think, suggesting if the employees had resigned, then they'd be able to recover under 103A. Obviously, those weren't the facts in that case. They didn't resign. It was just a detriment case. But it's not necessarily correct, as Ms Montraghi asserted, we would say, that they could recover under 103A. Because what happened in that case, as you can see at page 671 of the bundle, just taking it from the head note, so there were nurses who expressed doubts about qualifications and they were thereafter subjected to detriment. But if you read between E and F, the ET found that the claimant had been subjected to unpleasant and unwarranted behaviour by other staff as a direct result of the disclosure, pausing there for a moment, and there was no right to bring a claim then against a co-worker, in respect of which more could have been done by the employer and that they'd suffered the significant detriment of being removed against their will from working at the walk-in centre, but not because they blew the whistle. It held, however, that any failure on behalf of the employer to protect the claimants was not because they'd made the protected disclosure, that's the point I just made, and that the decision to redeploy and remove was taken because it was the only feasible way of resolving the problem. So if they'd resigned in response to that treatment, that would have been what is called a sort of mixed reasons dismissal. And so they may not have succeeded under 103A because it has to be the reasonable principal reason for the dismissal. And there, the ET found that the Employers Act was just to try and resolve the situation in the workplace and not because of the protected disclosures. And it's not necessarily right as well, and I'm traversing a bit on Mr. Jupp's submissions, it's not necessarily right that a subordinate act would be attributable to the employer, such that the employer would necessarily be held liable for that act. But we just don't know what would have happened on the factual matrix of that case, because that didn't happen.
Can you help me as to how applying 1A and reading it with subsection 2, how a worker can be subjected to detriment amounting to dismissal by an act done by a co-worker?
How the employee can be subjected to a detriment amounting to a dismissal
by an act done by a co-worker.
If the co-worker makes a decision to dismiss the employee, and the employee then gets a letter from admin because the co-worker told admin to send the letter, the reason
they're envisaging a co-worker who has the power to bring about the person's dismissal. We're not simply talking about the archetypal case.
The co-worker there is acting A as a co-worker and B as the employee, as the employer. So the co-worker is wearing the two hats of the separate legal persons of co-worker and employer.
Yes.
So it's a conflation of legal personalities to say there's no distinction between the two, and that's what Mr. Justice Bourne, that's the error we say Mr. Justice Bourne fell into in the EAT, and that's what the Court of Appeal said.
Well, that's all we're talking about here. We're not talking about co-workers who, for example, subject someone to a campaign of victimization, which then results in prolonged ill health leading to dismissal or something of that kind. The examples...
Well, that is another example which would amount to a dismissal.
But how in that situation can you say that the worker has been subjected to detriment amounting to dismissal by the act of the co-worker?
Well, the answer Miss Montraghi gave to Lady Rose was that the detriment in a constructive dismissal case is the co-worker, is the employee accepting the repudiatory breach, writing the letter of resignation.
No, that's the dismissal.
Yes.
The detriment precedes it.
Yes. But that is the cause of action in effect. But
But it's not done. See, the detriment amount, it's difficult to describe in that situation the dismissal as something done by the co-worker. One can say the circumstances that led to it were done by co-workers.
Yes. So everything that led up to it is done by the co-worker, and the dismissal.
But that's not what 1A is read with 2 is dealing with. The right not to be subjected to any detriment amounting to dismissal by any act done by a co-worker.
Well, we would say that detriment includes dismissal. So any act, any detriment that up to and including a dismissal, up to and including a termination, put it like that, put it more neutrally, would fall within 1A.
Well,
whether
you're not actually reading the legislation at all strictly. I mean, the detriment in question has to amount to dismissal under subsection 2, and then when you try to read that in 1A, the worker has a right not to be subjected to any detriment amounting to dismissal by an act done by a co-worker.
Yeah, well, we would say that a co-worker's act can never amount to a dismissal for the purposes of Part 10.
Right.
That is our bright line distinction between a detriment claim and a dismissal for the purposes of Part 10. So we say that they are completely separate, and so all the acts of the co-worker, including effecting the termination of the contract, could be claims brought against the co-worker, but the act amounting to a dismissal is a claim against the employer for the purposes of Part 10.
Well,
Right,
you compensated. Well, I was going to say the compensation, though, is for detriment amounting to dismissal. And I'm puzzled at the moment as to how the right not to be subjected to that detriment, that specific detriment, can be violated by a co-worker, unless you perhaps confine the provision to a co-worker who personally affects the dismissal, a managing director of a company or something of that kind.
In those circumstances, it might be. So all the losses.
Might.
it depends on the facts, with respect, my lord. But in those circumstances, all the losses flowing from the detriment which affect the termination could be claimed against the co-worker. So if the employer is insolvent and you only bring a claim against the co-worker, all your compensatory losses for loss of earnings would be claimable against the co-worker. And in a constructive dismissal case, exactly the same would apply.
But in the archetypal situations that Lady Rose described, where the co-workers are not people who have the power of dismissal, but they're people who have the power to make your life a misery, and perhaps to drive you into ill health, those people wouldn't be able to perform an act amounting to dismissal.
Yeah, our position is that no co-worker can perform an act amounting to dismissal. Only the employer can. And that's
But the employer must act through a human being.
Yes.
So there must be a co-worker who can effect an act of dismissal.
My lady, that's right. And
So how can you say...
But that is the key in this case, that the co-worker does the act, and so the act is the detriment at that point, but the employer is liable for the dismissal for the purposes of Part 10.
So the co-worker does an act amounting to a dismissal.
it does an act which is a detriment amounting to a termination.
Amounting to a dismissal, because the co-worker who has authority to dismiss can dismiss.
Well, that's right, but the dismissal is the dismissal effected by the employer. So they are conceptually different acts because they are done by different people, even though they might be exactly the same act.
But then you go further and say the employer is then vicariously liable for the different act of the co-worker.
Yes, that's what the amendments provide for.
But he can't be liable under this provision for the dismissal unless the co-worker was somebody who had and exercised authority to dismiss.
Well, they're liable for the detriment. They're liable for the detriment which affects the termination under this provision.
Well, I think we seem to be going, this all sounds rather circular to me. Anyway, we're a bit past 1 o'clock, so that'll give you an opportunity to perhaps collect your... Yes.
Can I just quickly raise one thing, which is concerning me, which is that this is coming up to us on applications to amend claims. And as was said right at the beginning, we don't know what the facts are and how they're going to pan out. That's how we're having to decide this, but I think there's a separate question on whether this kind of amendment should actually be allowed so that the claim can be comprehensive from the outset, given how it's not clear how the facts are going to pan out, and that later the Employment Tribunal may decide, well, actually, you should have put up with it, it wasn't so terrible, you've not been constructively dismissed, that there shouldn't then have to be a scramble to amend the claim. I just worry about how a decision on the structure of this should or shouldn't affect how claims are pleaded at the outset, if I can just express.
I also echo that, insofar as you can have multiple reasons for dismissal, and if the principal and sole reason isn't the whistleblowing activity, then that might feed into your second basis upon which you set out, and I think it's in paragraph 8 of your, paragraph 26 of your scale of Parliament.
Yes.
Statement.
Well, food for thought. We'll adjourn and resume at 2 o'clock.
Thank you.